You've been charged with assault with a deadly weapon in Arizona, and you're looking at the paperwork thinking, how is this possible? A bottle, a bat, a car? Arizona law uses the terms deadly weapon and dangerous instrument, and the definitions are far broader than most people realize. Prosecutors use those definitions to stack charges that carry serious consequences. If you're facing this charge right now, you need to understand exactly what the prosecution has to prove, what the real penalties look like, and the defenses that actually work. I'm Richard Suzuki. I was both a former federal and state prosecutor, now criminal defense attorney in Phoenix. I've been on the other side that builds these cases and the side that tears them apart. Let me show you both. What deadly weapon actually means in Arizona. Most people hear deadly weapon and think of firearms, knives, maybe, something clearly dangerous. But under Arizona law, the definition is significantly broader, and that matters how your case gets charged. Arizona makes a distinction that most people miss. A deadly weapon under A.R.S. 13105 is anything designed for lethal use, like a firearm or a knife, but there's a second category, dangerous instrument, which covers anything that, under the circumstances, is readily capable of causing death or serious bodily injury. A baseball bat, a car, a glass bottle, a rock. These are typically charged as dangerous instruments, not deadly weapons, but the legal consequences are equally serious. What makes an object a dangerous instrument? In court is a combination of the object itself, how it was used, and the vulnerability of the victim. This is why assault charges that might seem straightforward on first glance become complicated quickly, and why the charging decision by prosecutors involves judgment calls about what they think they can prove. For you as a defendant, this broad definition means two things. First, you might be charged with a more serious offense than the actual facts support. Prosecutors tend to charge at a highest level they can reasonably justify. Second, your attorney can challenge whether what allegedly occurred truly meets the legal threshold. The elements of the charge, what prosecutor has to prove to convict you of aggravated assault with a deadly weapon in Arizona. The prosecution has to prove beyond a reasonable doubt. That's a high standard. Several specific things. First, that an assault occurred. That means you intentionally, knowingly, or recklessly caused physical injury to another person or placed them in reasonable apprehension of imminent physical injury. Second, that the assault was aggravated, elevated from simple assault, specifically because a deadly weapon or dangerous instrument was used. Every element has to be proven. That means the prosecution has to prove your mental state. They have to prove the nature of the object used. They have to prove causation. And if that charge is based on apprehension rather than physical injury, they have to establish that the victim's fear was reasonable under the circumstances. These elements are where defenses live. If any one of them cannot be proven beyond a reasonable doubt, the charge fails. Defense 1, self-defense. Self-defense is one of the most commonly raised defenses in assault cases, and Arizona law's specific laws govern it. Under Arizona's self-defense statute, the use of deadly force is justified when you reasonably believe it was immediately necessary to protect yourself against another person's use of deadly force or serious physical injury. Arizona has a statute commonly referred to as stand your ground provision, meaning you are generally not required to retreat before using force in self-defense if you are lawfully present and not engage in criminal activity yourself. Self-defense is not a get-out-of-jail-free card. The prosecution will attack whether your belief was objectively reasonable, whether the force you used was proportional to the threat, and whether you were the initial aggressor. But when the facts support it and when properly argued, self-defense can and does result in acquittals. Defense 2, lack of intent. Arizona distinguishes between different mental states. Intentionally, knowingly, and reckless assault all carry different weights. If the incident was truly accidental, if there was no intent to harm, no knowledge to harm would result, and the conduct doesn't even rise to the level of recklessness, that can be a complete defense. This matters in scenarios where an assault charge arose from an accident that got framed as intentional by a motivated witness or where circumstances were generally ambiguous. The prosecution's narrative often fills in intent where the evidence is unclear. A defense attorney challenges that narrative with the actual facts. Defense 3, misidentification. Eyewitnesses' identification is one of the least reliable forms of evidence in the criminal justice system. Decades of psychological research confirm this, and yet it is used constantly in assault cases. If you are identified as the perpetrator by someone who was under stress at a distance, at night, or across racial lines, that identification deserves serious scrutiny. Your attorney should be looking at how the identification was conducted. Was there a lineup? Was it suggestive? Was the witness influenced by how the questions were asked? Were there other people in the area who could have been the actual perpetrator? In cases that hinge on a single eyewitness identification, attacking the reliability of that identification can be case dispositive. Sentencing. What are you actually facing? Aggravated assault with a deadly weapon or dangerous instrument is a Class 3 dangerous felony in Arizona, which is one of the more serious classifications. The sentencing range depends on your criminal history and the specific facts of your case. For someone with no prior felony convictions, a first-time offender, the presumptive sentence for that Class 3 dangerous felony is 7.5 years in prison. The range runs from a minimum of 5 years to a maximum of 15 years under A.R.S. 13704. And dangerous means a mandatory prison term, and probation is not available. You go to prison. With one prior historical felony conviction, the range goes up. With 2 or more felony convictions, your exposure increases. The dangerous designation is key. If the prosecution can establish the offense was dangerous, involving a deadly weapon or dangerous instrument, mandatory prison time is triggered. One of the strategic objectives in some cases is eliminated or reducing the dangerous designation, which can change everything about sentencing options. Plea versus trial. Understanding your option. I want to be direct about something. Winning a violent crime case doesn't always mean a not guilty verdict at trial. For many defendants, winning means the best realistic outcome given the actual evidence. That might be a reduction from a dangerous felony to a non-dangerous offense, which removes mandatory prison time. It might be a plea to a lesser charge that avoids the most serious sentence exposure. It might be a deferred sentence or probation on a negotiated resolution. The decision between plea and trial should be made strategically, with full information about the strength of the prosecution's case, the credibility of the witnesses, the available defenses, and the realistic range of outcome at trial versus through negotiation. I've seen defendants go to trial in cases they should have negotiated and pay a serious price. I've seen defendants take plea deals on cases that should have been tried and later wish they'd fought. The right decision requires honest assessment of the actual facts, not optimism or fear. That honest assessment, delivered by someone who knows both how the prosecution thinks and how to fight them, is what gives you the best chance and the best possible outcome. What to do right now if you've been charged or believe charges are coming. The most important thing you can do is stop talking about the case. Don't discuss it with friends, family, or anyone in the system. Get an attorney immediately. The decision made in the early stages of a violent crime case, before arraignment, during plea negotiations, and pretrial motions phase often determine the outcome more than anything that happens at trial. The earlier you have a skilled representation, the more options you preserve. We spent several videos in the state system: arrest, traffic stops, assault charges. In the next video, I'm taking you into the federal court specifically. And I'm going to tell you the things that most people don't find out until they're sitting at the defense table wondering what happened. The difference between state and federal court, what a detention hearing really is, how the United States sentencing guidelines work, and why the federal conviction rate is 99.6%. If you have any federal exposure whatsoever, that video is essential. I'll see you there.